On this morning's docket. That is case number 106107, State of Kansas v. Deborah Meeks.
May it please the Court, Samuel Shire of the Appellate Defender Office appearing on behalf of the defendant appellant Deborah Meeks. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
The primary issue in this case is whether the district court erred by preventing Mrs. Meeks from using expert witness testimony and specific instances of domestic violence to establish a self-defense defense. The right to present one's own defense at trial is guaranteed by our Constitution and fundamental. In determining whether a district court erred by not allowing a defendant to present his or her own defense, this court exercises de novo review. So based on what was proffered in this case, Mrs. Meeks was involved in a relationship with Mr. Smith. During that relationship, Mr. Smith repeatedly physically abused Mrs. Meeks, repeatedly raped her, repeatedly threatened to kill her family members. This is the evidence that would have supported a battered woman's defense. And I believe in the abstract, it's pretty clear that a defendant can put on evidence of battered woman syndrome to support a self-defense defense at trial. I believe that the issues before this court in this case are number one.
It's pretty clear that Stewart said basically you have to qualify for self-defense first, that you have to have imminent harm, for instance, and the Stewart majority did not indicate that's imminent through the eyes of a battered woman, did they?
No, Your Honor.
Okay.
They used just a regular reasonable person standard.
And we have, the problem I see here is we have defense counsel basically acknowledging that the facts did not exist for a classic self-defense, as he termed it, he or she termed it. And that's basically what Stewart says. You have to have a classic self-defense scenario before you can bring in the battered woman evidence, didn't it?
Well, Your Honor, I suppose it depends on what you mean by classic, and this cuts to part of the argument that we're raising on petition. I don't think that defense counsel was telling the district court that this was not a self-defense case. I think he was trying to express to the district court that this was not a typical self-defense case in that it relied on battered woman syndrome. Now, I believe Your Honor's interpretation of Stewart is correct, and part of my argument before this court today would be that it would be appropriate to revisit the holding of Stewart at this time. Simply put, I do not believe that Stewart was correctly decided.
And tell me exactly what we would change about Stewart.
Well, Your Honor, we know that imminent threat is not the same thing as an immediate threat. But if this court looks at how imminent was interpreted in Stewart, it was essentially immediate. I don't see a reasonable distinction between immediate and imminent based on the court's analysis in Stewart. I believe that immediate essentially means right before, to take place almost instantly, whereas imminent is something that is just ready to take place or is impending. And that makes all the difference in a battered woman syndrome case.
Go ahead.
I was just going to ask him to relate some of the facts in Stewart for our audience, but go ahead with your question, Justice Johnson.
The viewpoint, are you saying that the viewpoint is from that of a battered woman? Because what is perceived as imminent, immediate, or in the future, or whatever, is impacted by this particular syndrome, is it not?
Yes, Your Honor, and I think that aspect of Stewart is essentially quibbling over semantics. It's based, the test is a reasonable person based on the facts and circumstances of the case. So when you look at a self-defense defense, you don't look at it from the perspective of, well, you look at it from the perspective of all the circumstances known to the defendant, all the occurrences in his or her life leading up to that point, I believe.
In Stewart, the abuser was asleep.
Yes,
And
Your Honor.
basically what the Supreme Court said in that case is if the victim's asleep, you can't use battered spouse syndrome, correct? Or battered woman syndrome.
Yes, Your Honor.
And in
Okay.
this case, the victim was just sitting on the bed, and there was no evidence that there was a aggressive move by the victim.
I would say no evidence of an aggressive movement, Your Honor. However, based on the trial evidence, we know that Mrs. Meeks perceived the alleged victim in this case to give her a look like he was going to attack her. We know that there were 2 guns immediately within his arm reach.
Let's clarify that. Gave her a look after she had pointed a handgun at him and pulled the trigger, correct?
That's correct, Your Honor.
So how do we get around an aggressor cannot claim self-defense? If she pointed the gun and pulled the trigger, I would consider her an aggressor, and what happened afterwards would not trigger the justification for self-defense.
Well, Your Honor, 2 thoughts on that. First, I believe that Mrs. Meeks's theory of defense in her testimony, although not entirely clear, was that she was aiming to the side of Mr. Smith and pulling the trigger. Basically, that this was an action to scare him. And again, I think it's important to consider that decision from her in the context of battered woman syndrome, because from a normal person's perspective, that makes no sense. But I believe that Ms. Hutchinson, if she were allowed to testify at trial, could have explained that this was a not unusual phenomenon in a battered woman syndrome relationship. The second point I would like to make is...
You mean the choice to make a threat as opposed to a directly aggressive move? I'm sorry, what would be typical, you're saying?
I believe in Ms. Hutchinson's report, she stated that victims of battered woman syndrome often use weapons as a type of equalizer. And I think that's what was going on in this case, is that Mr. Smith, through his repeated acts of abuse, had made Mrs. Smith feel that she was completely worthless. And this was her way of trying to equalize the situation. But the other thing I would like to make a point of is that I do not believe in this case that Mrs. Meeks was the aggressor. According to preliminary hearing testimony, it appears that just hours earlier, Mr. Smith had threatened Mrs. Meeks with a gun and said something to the effect of, "I'm going to kill you." Now again, this would cut sort of back to the imminent versus immediate issue, but I would say that in this case, this is sort of the textbook case of why this court should interpret imminent more broadly than the Stewart court did. I think a reasonable jury looking at this facts could easily conclude that it was only a matter of time before somebody was seriously harmed in this relationship. Put another way, I think a jury could have found that Mr. Smith was going to kill Mrs. Meeks or perhaps one of her family members unless he was incapacitated. And I believe that by not allowing Mrs. Meeks to pursue self-defense in this case, it would be essentially what courts have described as condemning her to murder by installment.
I'd like to go back to, a factual question. Justice Johnson asked you a question, and your answer was to the effect of, well, she had aimed the gun to the side of his head and pulled the trigger, which would suggest she was just trying to scare him. Is that correct?
That's correct, Your Honor.
My question is it clear from the record whether she put it alongside his head to scare him, or she pointed it at the side or the temple and pulled the trigger and it did not go off?
Your Honor, based on my reading of her trial testimony, I believe that it's somewhat ambiguous, and the problem here is that apparently she was motioning in her testimony.
She was gesturing that would have been clear to a jury, but not on the record, is what you're saying.
Yes, Your Honor, and I believe that the theory of the case was that she was just trying to scare Mr. Smith, and then when Mr. Smith reacted to that, that's when the very immediate necessity of exercising force to protect herself would have kicked in.
One last factual question. My understanding is that the gun that she used had been given to her by the victim. Is that right? Mr. Smith gave her a gun in this abusive relationship, and then she took that gun, cocked it, went to the house, and put it by his head, against his head, to the side of his head, and pulled the trigger. Is that right?
That's essentially correct, Your Honor.
And do those facts, in your view, have any bearing on whether she's entitled to have the battered women syndrome as a basis for her defense?
I think that yes, Your Honor, because it explains those actions as to why she would do that. In this case, the gun was her method of equalizing a very dysfunctional relationship. I would also say that the past instances of abuse would also come into play here, those which were excluded, because those would explain why she would need to take a loaded gun to the house. She was in a position where if she went to that house, she needed to protect herself because Mr. Smith had repeatedly threatened to kill her and had repeatedly physically and sexually abused her.
Let me stop you for just a moment. I think we understand that was the history of the relationship. I'm trying to understand further how many layers you're arguing here that battered women's syndrome was relevant and should have been and evidence of it should have been permitted. It sounds to me like you're saying that it should have been permitted because it explained why she went there in the first place. Is that right? Because there was this escalation had begun, a cycle had begun again, and she knew where it was headed. Is that correct?
Yes, Your Honor.
Okay, so that's one use of it. And that would make her the non-aggressor. In other words, she was going to use this equalizing weapon to demonstrate some power in this cycle. That's your first argument.
Yes, Your Honor.
Okay. But you're also saying that it should be considered in some way in how she perceived the look that he gave her after she attempted to fire the weapon and was unsuccessful. Is that right?
That's also correct, Your Honor.
Okay. And so the imminence comes in her going to the house, or in her perception of the look, or in both? Because that's yet a third layer, it seems to me, where you're trying to employ the syndrome.
Your Honor, I would say both.
Okay. Okay. So there are essentially three layers to where the syndrome, what you're saying, the syndrome should be relevant under our law.
Yes, Your Honor.
Okay, thank you.
Another fact question, since we're just addressing fact questions. It seems that the Hutchison report talks a lot about the classic signs of battered women symptoms and the effects of battered women syndrome. But is there ever a diagnosis that Mrs. Meeks suffered from battered women syndrome?
There is not a formal diagnosis included in the report, Your Honor. However, all of the findings and analysis that Mrs. Hutchinson made, to me, clearly indicated that this was a battered woman's diagnosis.
But how do we deal with that? I mean, can we even reach Stewart or anything else where we don't have a clear record here that Mrs. Meeks suffered from battered women syndrome?
I believe you can, Your Honor, because what we're raising in this issue is the problem that defense counsel wasn't able to present this defense. So whenever you have a right to defense issue, there's always going to be the problem of, well, we can't say for absolute certain what would or would not have been proven at trial. But what we can say is that the district court said any evidence of battered woman syndrome is inadmissible.
But we would expect a proffer sufficient to support it, I think. And do you feel the record is sufficient in that regard?
Yes.
And why? Just for the reasons you stated or anything else?
Your Honor, I would say it's sufficient because of the detail in which she describes Miss Meeks's mental conditions. Those are all indications of battered woman syndrome. The learned helplessness, for example. If this court looks at symptoms that are discussed in prior cases of this court, I believe that it would find that Mrs. Hutchinson's report touches on all of those symptoms.
I'm having trouble with your assertion that the Court of Appeals erred in its decision when it said that a self-defense defense wasn't being raised by the defendant. And that is your argument. That, in fact, I think you say in your brief that the Court of Appeals was absolutely wrong on that. And I go through the pleadings, and I see many instances where defense counsel says, I'm not raising self-defense. I mean, he says here in the motion, in the response to the state's motion to exclude evidence of past relationships, he says, while the defendant did not act in self-defense at the time the gun discharged. I mean, that says there's no self-defense. And so I don't understand really what's your starting point, which is that the Court of Appeals was wrong when it found that there was no self-defense defense raised. And then you couple that with the fact that no instruction was requested by the defense. I mean, I don't see how. I think you're making something, stretching what happened here further than you can. And so this is the concern I have. It seems to me that what the defense counsel wanted to do was explain that the battered spouse syndrome comes to play as to why she brought the gun from her home back to the defendant's house, but not that it had a play in when she pulled the trigger. Does that make sense?
Yes, Your Honor. And in response, I would say that defense counsel wanted the evidence to come in for multiple reasons. In the particular pleading that you referenced, that occurred after the district court had made its prior motion in limine ruling. So that ruling shapes the current theory of defense counsel's case. And that's also, I believe, a reason why a self-defense instruction was not requested in this case.
Well, defense counsel requests, I mean, you make a record and you say, you know, I got a self-defense theory here and you're not letting me use it, Judge, and I want to ask the appellate courts later whether you're wrong. So you make that kind of a record. and he doesn't do it. And I think it's because, from reading several statements, not just this one, I mean, I'm not just plucking this one out. I mean, it seems to me that defense counsel is not trying to raise self-defense when it comes to the issue of pulling the triggers. I don't see it. And can you point me to some place in the record that it clearly says, I want to raise self-defense and you're not letting me do it?
Yes, Your Honor. And this would be at the motion in limine hearing. And I would just say, certainly this issue could have been preserved better, but it was preserved. What defense counsel states at the first motion in limine hearing is, quote, there's not going to be what you would consider a classic self-defense defense in this case. However, the state of Kansas since 1986 in State versus Hodges has approved of battered woman syndrome evidence. Hodges is a case in which a defendant wanted to admit evidence of battered woman syndrome to support a self-defense defense. So I think this puts the court on clear notice that self-defense is part of the reason why he wants this battered woman's evidence to come in. And the district court subsequently made a ruling that self-defense was not applicable in the facts of this case.
Any more questions?
I have one more. Are you disputing that a defense theory of self-defense is a condition preceding to the introduction of any evidence of battered woman syndrome?
Can
you put on evidence? Could Dr. Hutchison have testified if there had not been a self-defense defense?
Yes, there are other contexts in which it could have come in, I believe, Your Honor.
And what would that be? You indicated to explain why she went back to the house, but why is that relevant? If self-defense isn't on the table, why is it relevant why she went to the house? All that's relevant is that she intentionally shot the guy. She was convicted of second degree, right?
Yes, Your Honor. And I guess in answering your question, I was just meaning to convey that I could imagine other situations where battered woman syndrome would be admissible for purposes other than establishing a self-defense instruction or a self-defense case.
And so Stewart was wrong in that regard, and I think Hodges said that it's only relevant for self-defense to show the how it's viewed from the defendant's standpoint.
Well, Your Honor, I guess I would have to defer to the specific language in those cases, but my interpretation is that they are just looking at the narrow issue in front of them. Did it support this self-defense theory of defense in this case?
Okay, in this case then, the case before us, was self-defense a requirement to get Dr. Hutchison's evidence into the record?
Your Honor, it was not raised in the briefs. However, I believe that a lack of intent defense could have been pursued based on Ms. Hutchinson's report.
Any further questions? Thank you, counsel.
May it please the court, Cheryl Lidke on behalf of the state of Kansas. To answer the last question that was asked about whether battered spouse syndrome was admissible for any purposes other than self-defense, Justice Johnson, we believe the only other way to get into that would have been to offer it as evidence to negate the requisite intent under 223220. And in order to present it under that statute or that theory, the defendant has to have a mental disease or defect. And clearly, I think that's why Dr. Hutchinson had problems putting the words in her report, because this defendant did not have a mental disease or defect. She may have been in a toxic relationship with this man for years, and that affected her, but it didn't rise to the level of being able to negate the requisite intent. I think those are the only two ways that you get into this evidence, and the only ways that it would have been relevant. It wasn't relevant under a self-defense theory because she wasn't asserting a self-defense theory. In fact, never requested an instruction on self-defense. And so we believe that the lower court was proper in excluding the evidence of Dr. Hutchison's report or her testimony.
Well, how could
And the
she
Court of
assert? How could
Appeals-
she assert a self-defense when the motion in limine precluded any battered women's syndrome evidence? And you said the other context that comes in is mental disease or defect. She wasn't asserting that. Once she was precluded from bringing in that expert testimony, self-defense is gone, isn't it?
Well,
I mean,
the only-
every conduct, starting with Hundley, that's the whole focus of this, and turning in the courts interpreting immediate and imminent, and all of that has to do with asserting self-defense and explaining self-defense. And once that's precluded, how can you raise it?
Well, I think it's important to point out that the defendant, even when he asked for the evaluation by Dr. Hutchison, was conceding that he was not, or that she was not going to be asserting a self-defense argument in this case. So I don't know if that was a concession that the facts underlying in this case did not rise to the level of a self-defense argument. I don't know what they were conceding, but I think it's important to note that even before they asked for the evaluation by her, they were conceding on the record that they were not going to be asserting self-defense. I don't know if that answers your question, but I think that's a significant factor in the analysis.
So at that point, their goal was to have an expert say that she did suffer from a mental disease or defect?
I think that's the only thing. I fought to keep the evaluation from being done in the first place because I didn't think it was relevant to have an evaluation unless you're going to assert self-defense, and since they weren't, I said, why are we paying for an expert to do this? So I think Judge McNally's analysis was probably, well, it could be relevant to go to this requisite intent question. But then it didn't even answer that question. So it wasn't admissible after the evaluation was done either. And so then I did a motion to keep it out completely. But I don't know. I think the judge was very sparse in his words when he granted the motion to do the evaluation. But I'm assuming that that's why he allowed it and thought it might have some relevance if it would address the issue of requisite intent.
Are you aware whether the DSM-5 deals with battered woman syndrome?
I think it has it as one of the subsections of post-traumatic stress disorder, that it's recognized as a syndrome, but it stems from post-traumatic stress disorder. And absolutely nothing in Dr. Hutchison's report addressed that or claimed that this defendant had that. So I guess
I'm sorry, you've lost me on the, you fought to have the report done.
Yes. I didn't think the defendant was entitled to even have an expert paid for by the state of Kansas to do an evaluation of this sort because she was not claiming self-defense and could not under the facts in this case.
So that was your position, that she could not support it. It's not supported under the facts of this case because of State v. Stewart, or why?
Yes, primarily based on Stewart and our statutes on just the doctrine of coercion itself requires that, well, you can't use this doctrine to defend a case if you have a reasonable opportunity to avoid
Well,
putting
So
yourself
you're
in that-
relying on, so even at the outset, your claim is this is not a self-defense case. So
Right.
either defense counsel had to argue, yes, it is, or
concede that it wasn't.
concede that it wasn't, based upon the current case law, right?
I suppose that's a fair assessment, yeah.
In my disagreement with that, and maybe even your concession, is as I'm reading the transcript here from your motion to exclude the expert report, which, you know, if I understand the sequence, they asked for, the defendant asked for the expert, you oppose it, but the court grants it.
Correct.
Go ahead and do the evaluation. Then you show up and say, wait a minute, this expert report doesn't say that she has battered spouse syndrome, so it doesn't have any relevance. And then before the court's made any ruling, defense counsel takes off the table self-defense, saying, I'm not raising self-defense here, and I'm not raising battered or a diminished capacity.
Correct.
So this is before the court's made any, so the court hasn't dictated anything to the defendant. Am I right about that?
Yes, and it wasn't just at the hearing on the motion to exclude the expert's opinion. It was at other hearings, as early as the motion for the evaluation, that the defendant was making those assertions to the court, that he was not, or she was not going to assert self-defense.
But was that was that in response to your initial argument that this is not a self-defense case, given the facts of the case and what we have in State v. Stewart? Wasn't that your primary argument at the outset?
I'm not sure that I can get into the mind of the defense attorney.
No, I'm talking about you.
Yes, I had made those arguments from the outset.
From the outset.
I don't know.
And so this case was framed by what the parameters of our current case law that was outlined in State v. Stewart.
But part of my setting out that argument included the fact that the defendant had never asserted it and had in fact said that they were not going to assert it. So I don't know that you can say that it was me that first came up with the idea that she's not going to assert it. But I heavily relied upon that in my arguments to the court during the hearing.
Counsel,
Go ahead.
I'm just going to ask, was there any point in any of these proceedings where the defense counsel said, yes, we are asserting self-defense?
No. But I will say that during the trial, Ms. Meeks testified, and I think you could take part of her testimony to say that she was acting in self-defense. But it was never asserted as an affirmative defense at any point prior to that. But I think she used some words like, I felt like I needed to defend myself at some point during her testimony.
And the instruction conference took place after her testimony?
Correct.
And there was no request at that point for self-defense instruction, is that
Correct.
right? Okay. Thank you. Justice
Right.
Johnson.
He did mention Hodges, correct?
Yes.
That he wanted to introduce the battered woman syndrome evidence pursuant to Hodges, or because Hodges said so.
Oh, I don't remember if that's what he relied on, but I'm aware of the Hodges decision.
And Hodges basically talked about that the syndrome evidence was relevant to view the defendant's perception of danger through the lens of a battered woman rather than the run-of-the-mill, reasonable, objective person.
Right, but even Hodges dealt with self-defense.
Right. And Stewart then is a little inconsistent because Stewart said that you basically have to fit within self-defense, that you have to show the imminent harm before you can introduce the battered woman syndrome evidence.
Right, they disapproved of the subjective
And
test.
so, what is the point? If you meet all the elements of self-defense, what is the relevance of battered woman syndrome evidence?
Well, just to explain the perceived danger that they had and why they felt like they needed to defend themselves.
If Stewart says basically that you use the reasonable person objective standard
For the second part.
Right. So you're saying
It can help to explain the subjective.
the subjective part is what you're saying?
Right, even Stewart uses the hybrid test that says that you have to have, the defendant actually has to have an actual belief that they're in danger, and that's a subjective test. But then there's the second part, which is that it has to be a belief that reasonable people would think under those circumstances you would have to defend yourself. So I think it could still be relevant under that subjective first test.
Do you agree with the way in which Stewart handles imminence versus immediacy? I mean, do you think Stewart's subject to criticism because of that portion of the decision?
I really haven't thought about it because in this case, she didn't have imminent or immediate danger. This was a case where he's just sitting on his bed eating his hamburger, and she walks in, and to answer the question about how close she was to him when she tried to fire that first shot, she was at the end of the bed. She wasn't next to him and did not have the gun pointed or pressed up against his head. She was at the end of the bed. He's sitting up at the top of it, and she's pointing in his direction. And I think that's what the Court of Appeals noted in their recitation of the facts.
So she's facing him?
She's facing him. They're looking at each other, and she holds the gun and points it at him in his direction and tries to fire. She pulls the trigger, and there's a defect in the gun, and so it doesn't fire. A bullet falls out, and so then she tries it again, and that's the shot that goes off and kills him. So I don't know the answer to your question. In this particular case, she wasn't in either imminent or immediate danger when she fired the shot. We're here asking you to affirm the Court of Appeals decision, which affirmed the lower court. Court of Appeals relied heavily on Stewart in finding that the battered woman syndrome was only relevant evidence if she was asserting self-defense, and that even if she had tried to assert self-defense in this case, there were not facts that would have supported that defense. And if there are no other questions, then I'll rest on my brief for the second issue.
Any more questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Unless this court has any questions at this time, I am prepared to waive my rebuttal at this point.
I have a question at the hearing on the motion to exclude the expert testimony. The district court judge, it seems to me, says, you know, there may be some stuff in this Hutchinson report that might be relevant, but I'm not seeing it. And then asked Mr. Sexton, the defense counsel, if he has any case law that he can provide the district court that would show. Do you recall that testimony?
Yes, Your
And do
Honor.
I reflect it reasonably accurately?
Yes, Your Honor.
Where's the case law that the district court requested to find some relevance to the material that was in there? Where will I find that in the record?
It is not in the record, Your Honor.
Is that because it wasn't done?
Presumably, Your Honor.
Any more questions?
Just one factual question. My understanding was that the defendant had acknowledged that the physical abuse had stopped years earlier.
The defendant had acknowledged that the physical abuse had stopped.
That early on, when she got pregnant with their child, that she was subjected to physical abuse, but that part of the abuse had stopped, and that it was basically emotional abuse subsequently. Am I seeing the wrong stuff, or?
Well, Your Honor, I believe the report indicates that Mr. Smith told her, you will have oral sex with me or I will kill you. To that effect, I would consider that violence, but I'm not aware of physical violence in the sense that contact is being made.
Well, the record, it will be what it is. Yeah.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement